That concludes the debate on support for the veterans and armed forces community in Scotland, and it's now time to move on to the next item of business, which is a debate on motion 20037 in the name of Neil Gray, on a motion on legislative consent for the Terminally Ill Adults End of Life Bill, UK legislation. I'd be grateful if members who wish to speak were to press their request to speak buttons now. And I call on the Cabinet Secretary to speak to and move the motion. Up to 6 minutes, please. Presiding Officer, I move the motion in my name, and I thank you. This debate is about whether the Scottish Parliament should give its consent to Clause 43, prohibition on advertising in Kim Leadbitter's Terminally Ill Adults End of Life Bill. I'm speaking today to the provision as described in the motion. My recommendation on behalf of the Scottish Government is that the Parliament gives its consent. The motion in front of Parliament today is necessary to protect the constitutional settlement in the normal manner of legislative consent motions and is not a comment on the content of Ms Leadbitter's bill. The Scottish Government does not have an opinion on the content or principle of that bill, for which it is the UK Parliament's responsibility to scrutinise. Ms Leadbitter's bill has no effect on Liam MacArthur's Assisted Dying for Terminally Ill Adults Scotland Bill, and neither does this motion, nor the two bills should be conflated, as they are undergoing very different processes in their respective parliaments. The Scottish Government's view is that Clause 43 is for a purpose within the legislative competence of the Scottish Parliament, considering the C7 reservation of the Scotland Act. The C7 reservation covers regulation of, among other things, I quote, misleading and comparative advertising, except regulation specifically in relation to food, tobacco and tobacco products, end quote. It does not reserve advertising generally. As such, we believe that the Scottish Parliament's consent is required for Clause 43 and that this should be given so that we do not find ourselves in a situation where the English and Welsh assisted dying service can be advertised in Scotland but not in England or Wales. Presiding Officer, I turn now to the substance of the provision under scrutiny today, Clause 43 of the Terminally Ill Adults End of Life Bill, that imposes a duty on the Secretary of State to make regulations to prohibit the publication, printing, distribution or designing of advertisements whose purpose or effect is to promote the England and Wales Voluntary Assisted Dying Service. The purpose of Clause 43 is stated to be to prevent pressure from being put on vulnerable people or the undermining of national suicide prevention strategies through the unethical advertisement of the England and Wales service. By consenting to this provision, the Scottish Parliament would be agreeing that the English and Welsh service, if introduced, could also not be promoted in Scotland. Effectively, we are making sure that Scotland could not be used to advertise this service and closing what would be a gap in these islands if the bill is passed and such a service is established. Regardless of personal views on assisted dying or Ms Leadbitter's bill, I doubt any member would wish to see such an anomaly. In addition to lodging a legislative consent memorandum, I gave evidence to the Health, Social Care and Sport Committee on the 23rd of September, where I set out the Government's position, as I have for Parliament today. I have also responded to questions raised by the Delegated Powers and Law Reform Committee around the scope of the powers in Clause 43, noting that our recommendation to consent was based on the substance of the provision, not the scope of the enabling power, which will be determined by the UK Parliament. In that response, I noted, and this was acknowledged by the committee, that the exercise of the power is likely to have a very limited impact on the law relating to devolved matters in Scotland. Both committees have since indicated that they are content with this motion and our recommendation to consent. To conclude, Presiding Officer, I hope that Parliament finds that explanation and outline helpful in setting out the Government's position, and I urge members to agree to give consent to Clause 43 insofar as it relates to devolved matters being considered by the UK Parliament. Thank you, Cabinet Secretary. I now call on Claire Haughey on behalf of the Health, Social Care and Sport Committee.
Thank you, Presiding Officer. The Health, Social Care and Sport Committee undertook scrutiny of the legislative consent memorandum in respect of the Terminally Ill Adults End of Life Bill during September of this year. During the House of Commons report stage on this bill, several amendments were agreed to which extend the scope of certain provisions to Scotland. As the bill sponsor, Kim Leadbitter, concluded that the legislative consent process was not engaged by any of these provisions. The Scottish Government agreed with this assessment, except with respect to Clause 43, which makes provision for regulations prohibiting the publication, printing, distribution or designing anywhere of advertisements whose purpose or effect is to promote a voluntary assisted dying service or a VAD service, and prohibiting causing the publication, printing, distribution or design of such advertisements. For the avoidance of doubt, a VAD service for the purposes of this clause means the services as set out in accordance with the Act, that is, VAD services in England and Wales. It would therefore not apply to any such services in Scotland where the Assisted Dying for Terminally Ill Adults Scotland Bill to become law. However, I note that the issue of advertising was actively debated during Stage 2 proceedings in that bill, and an amendment was agreed which introduces a new section to the bill that creates an offence of advertising assisted dying. We began our scrutiny of the LCM by writing to selected stakeholders to request their written views, and a number responded they had no comments. The committee also received a detailed submission from Alzheimer's Scotland, which raised certain points about the LCM. These included highlighting the importance of careful alignment between any UK and Scottish Parliament legislation on assisted dying to avoid confusion, duplication or conflict. The submission emphasised the need for robust definitions to ensure a clear distinction between prohibited commercial promotion that may result in exploitation and permitted factual information. It raised concerns about the implications of the provisions covered by the LCM related to Article 10 of the European Convention on Human Rights, arguing while limitations may be justified to protect vulnerable individuals from inducement, they must be proportionate and clearly defined. And it concluded by recommending clear mechanisms to establish how any resulting prohibitions would be applied and overseen in Scotland. As part of its scrutiny of the LCM, my committee received assurances from the Cabinet Secretary for Health and Social Care that the relevant provisions would only apply to what would commonly be understood as advertising and would not result in prohibitions being placed on the publication of factual information, for example, about the service in question or how it should be delivered. On this basis, and on the understanding that the scope of these provisions is limited to the advertising and promotion in Scotland of a voluntary assisted dying service in operation in England and Wales, my committee has concluded its scrutiny by recommending that the Parliament agree to a legislative consent motion in similar terms to the draft motion included in the draft LCM S662.
Thank you, Ms Hockey. I now call on Jackie Bailey.
Presiding Officer, both the Scottish and UK Parliaments are currently, of course, scrutinising assisted dying bills. And whilst we may be doing so on slightly different timelines, the reality is that the debates are very similar and the nature of amendments being considered are largely in the same territory of enhancing safeguards. Wherever you stand in the debate, it is acknowledged that both bills, if successful, will have a profound impact on people across the UK. So it is right that the two parliaments should work closely together. This is particularly the case when it comes to advertising and media, where online activity travels much more easily across borders than a poster, for example, on a wall. And in the recent House of Lords debate that considered this, it was noted that those with chronic illnesses have reported noticing Facebook adverts that include negative content about their treatment, whether they can live with their condition, and even suggesting going to Switzerland for assisted dying. If Facebook algorithms are opaque, AI is even worse. And the House of Lords debate also referenced the current lawsuit against OpenAI from the family of a young man who alleged that ChatGPT encouraged him to take his life. So once again, this bill is a reminder of the work that governments must do to make sure that there are appropriate safeguards in place. Combating advertising which targets vulnerable and suicidal people is an issue that government should be working closely together on, regardless of the outcome of these bills. So we on the Labour benches support the legislative consent motion.
Thank you, Ms Bailey. I now call on Patrick Harvey.
Thank you, Presiding Officer. And I'll be fairly brief, simply to set out the hope that I have that there's broad consensus on the LCM before us. I would like to hope that, as I think the Cabinet Secretary said, regardless of the range of views on the merits of legislation, either here in the Scottish Parliament or at Westminster, that very few people would want to see advertising playing any role at all in the issue of assisted dying or any equivalent legislation at UK level for England and Wales. As others have said, this is an issue that's been debated in both parliaments in relation to both pieces of legislation. And I think when we debated that, my only additional concern was that we should ensure not only that we're being clear that we don't expect and don't want to allow advertising to play a role, but also that we don't inadvertently make provisions against advertising also inhibit the provision of factual information about the services, or indeed arguments about the policy merits of the legislation or how services should be delivered. And I asked the Cabinet Secretary when we considered the LCM in committee if it was his expectation that the restrictions we're talking about would apply to advertising alone, and he agreed. I do think that we considered a range of different possible restrictions in the Scottish legislation, and I had similar concerns that some variants of what was being proposed might have had more of an inhibition on the expression of legitimate opinions about assisted dying, or indeed potentially about research or the provision of factual information. So as we go forward, either in working with UK Parliament colleagues to ensure that the legislation is in fit shape there, or in scrutinising Liam MacArthur's bill at stage 3 in this Parliament, I do think that we need to make sure that we're paying due attention to both aspects of this concern. Not only that we don't allow advertising to play a role in a way that none of us would be comfortable with, but also that we ensure that we don't inhibit legitimate debate and don't see the use of material on social media, for example, to influence or put pressure on people to make a decision in either direction. Thank you, Presiding Officer.
Thank you, Mr Harvey. I now call on Liam MacArthur.
Thank you, Presiding Officer. I'll probably start where Patrick Harvey left off. I think where there are disagreements on the principles around this bill across this chamber, I think where we can coalesce is as a concern to ensure that advertising of assisted dying, whether in England and Wales or in Scotland, is robustly prohibited for the reasons other colleagues have set out. I think Patrick Harvey and indeed the convener earlier, quoting the contribution from Alzheimer's Scotland, I think has pointed to the balance that needs to be struck here, where we all, I think, understand the importance of ensuring that access to factual information and need advice. Some may even need some support in navigating the system, that is available to those that need it, while still guarding against the risks that I think Jackie Bailey very fairly highlighted in terms of the promotion, not just the advertising, but the promotion of assisted dying services. So I think I've not got a great deal more to add. I think the Cabinet Secretary set the scene very well in explaining what this is and indeed what it is not. There will be time enough for further debates on my bill and indeed on this issue. The committee considered amendments in this area which I think went some way, but as Patrick Harvey suggested, maybe went slightly too far in potentially impacting on the access to information, which is absolutely crucial. But Parliament will have an opportunity to return to that at stage 3 and hopefully make sure that the protections in this bill are as robust as they need to be. But I thank again the Cabinet Secretary for setting the scene on this and hope that Parliament will back the LCM at decision time.
Thank you, Mr MacArthur. I call on the Cabinet Secretary to wind up.
Presiding Officer, I have nothing further to add to the arguments set out in my opening statement. I'll rest on the arguments that I set out and again urge Parliament to support this LCM.
Thank you, Cabinet Secretary. That concludes the debate on a motion on legislative consent for the terminally ill adults end-of-life bill UK legislation. It's now time to move on to the next item of business, which is consideration of Parliamentary Bureau Motion 20067 on a committee meeting time. And I ask Graham Day, on behalf of the Parliamentary Bureau, to move the motion.
Move, Presiding Officer.
Thank you, Minister. The question on this motion will be put at decision time. I have a point of order from Douglas Ross.
Thank you very much, Presiding Officer. On the 25th of November, during a question session on the National Grooming Gangs inquiry, I asked the Minister responding, Natalie Dawn Innes, if the Scottish Government would release all correspondence between themselves and Professor Alexis Jay. The Minister said at the time she didn't have that information available, but would write to me. The Minister has written to me this afternoon, and in her letter she says, I explained that I did not have this information available at the time and committed to providing it in writing. That is a quote from the Minister. But her very next paragraph states that the Scottish Government is now going to treat this as a Freedom of Information request because they have had similar Freedom of Information requests on this topic. And she concludes her letter by saying, we expect this information to be published by the end of this year. I have so many concerns about this. Is it right that the Government can commit in this chamber to provide information to a member who has requested it and then change that to say it will be part of a Freedom of Information response? Is it acceptable for the Government to say that they will provide it by the end of this year, which could possibly be while we are in recess and there is no opportunity for Parliament to scrutinise this? I'm further concerned that this Government have inserted a statement on the National Grooming Gangs inquiry or efforts that they will take forward around this for next Wednesday, and we now potentially will not have crucial information that was promised in this chamber because it's been treated as a Freedom of Information request, which may not be answered until the end of the year. So I'm making a direct plea to you, Presiding Officer, as our representative in this Parliament, seeking to get answers for MSPs to then allow us to respond to our constituents. Can you use your influence or any powers and standing orders to say to the Scottish Government it is completely unacceptable to promise one thing and then change it, and urge them to provide this information as a matter of priority because it is needed now, not when it suits the Government by the end of this year?
Thank you, Mr Ross. The Scottish Ministerial Code states that the Scottish Government should be accountable to the Parliament, and as a matter of courtesy and respect, I would expect that where a Minister cannot provide information in answer to a question in the Chamber, and where the Minister has committed to providing that answer in the Chamber, they should undertake to provide such detail to the member as soon as it is available. Thank you. I'm minded at this point to accept a motion without notice under Rule 11.2.4 of Standing Orders that we bring decision time forward to now, and I would invite the Minister for Parliamentary Business to move the motion.
Move, Presiding Officer.
Thank you, Minister. The question is that decision time be brought forward to now. Are we all agreed? There are 6 questions to be put as a result of today's business. And the first question is that Amendment 20036.1 in the name of Daniel Johnson, which seeks to amend Motion 20036 in the name of Richard Leonard on behalf of the Public Audit Committee on the 2023-24 audit of Ferguson Marine, Port Glasgow Holdings Limited, be agreed. Are we all agreed? Yes. The Parliament is not agreed, therefore we'll move to a vote, and there will be a short suspension to allow members to access the digital voting system.